No sounds? What an idiot. All right, we're back. Hello, my friends. Welcome back to another episode of Watching the Watchers Live. This time, hopefully, with audio. We are here waiting for the Supreme Court to come down and give us an order, a ruling imminent in the Mercan Alvin Bragg prosecution. Trump's sentencing is scheduled for tomorrow at 9:30 in the morning. And so if anything breaks, if anything happens, please let me know, just like you did with our audio problem, because we're paying close attention to the Supreme Court docket. Here's what it looks like. As you can see, we've got the application submitted. We've got former public officials and legal scholars all submitting their amicus briefs. And so we're going to see what is inside of those things, because tomorrow morning is the drop dead date. Then we'll take a look at what's happening over in Florida. And in Florida, we've got the 11th Circuit where there's another battle afoot, and more amicus briefs are coming in on this one too. And Trump's team has actually said that they want to submit a filing, and Judge Cannon just today came out and said, great, we'll hear from the president. So President Trump also has now submitted an amicus brief. Yesterday on the show, we were reading through Walt and Carlos's brief, but today we'll have the president's, and we're also going to see some familiar faces back here named Edwin Meese and Professor Stephen J. G. Calabresi. And those guys were very instrumental in the battle to disqualify illegitimate Jack. If you recall, they initiated a lot of the filings that went directly to Judge Cannon, and we know where that went. So a lot of good stuff cooking today. Apologies on the audio. We've got locals fired up, Rumble, YouTube, of course, is here. And it's a beautiful day, my friends. If you haven't already, and you don't have any plans for inauguration, come and join us. We're having an in-person watch party in Scottsdale, Arizona, aka the Mar-a-Lago of the Southwest. We'd love to have you come join us. January 20th, 9 a.m. We've got tickets available at watcherlodge.com. They're $100. They include the food, they include the venue, they include the fun and the friendship. And so grab your tickets, watcherlodge.com. We're working on a digital pass as well. And of course, we're going to be streaming the inauguration here. So thanks for subscribing, but then we'll have a backstage pass for the event. And we're excited about that. So I know many of you are coming. I cannot wait to meet you and see you. Sergeant Bob is going to be coming with his books. It's going to be great. So come join us, watcherlodge.com, and grab your tickets. Link in the description below. All right. So let's turn our attention to the business on the day. The Supreme Court is imminent in a decision. We're waiting for it to drop any moment. We have now Trump and his defense team trying to stay the sentencing, which is due up in less than 24 hours. And we've got a bunch of stuff that has happened since we last spoke. Yesterday, we talked about Trump's application to Justice Sotomayor. We read through the full brief. Be sure to check that out. We also saw that Sotomayor came back and said, Alvin Bragg better respond by today. He has now done that. We've got his response, and we'll read through it to see what his argument is, because it seems like he's just making the jurisdiction argument, which is one of the weakest arguments ever, because they're the Supreme Court, okay? They've got jurisdiction over everything. And then we've got Ed Meese and Steve Calabresi, who are coming in, offering major support to President Trump. And these guys were right the last time we had a battle with Jack Smith and got his case essentially thrown out. So that was an amazing assist. And now they're coming back at the Supreme Court and they're saying, listen, this sentencing cannot happen. They were in the Jack Smith case, but now they're on the Alvin Bragg case. And then we'll look at some of these legal scholars, all right? If you ever hear anybody call themselves a legal scholar, you should question that immediately. Doesn't mean they're not, just means you should question it immediately, because most legal scholars aren't going to call themselves a legal scholar. Okay, that's kind of an idiotic thing to say. Anyways, so January 9th, we've got a bunch of stuff cooking. We've got sentencing coming out January 10th, if it happens, unless the Supreme Court comes back down and issues an order. And so we're planning on live streaming all day tomorrow morning, starting early, in case this thing drops. Now, Trump had two avenues of attack to try to stop this sentencing from moving forward. One was in the New York State Supreme Court, which is called the Court of Appeals there, but it's the highest level court. And the other was in the federal court, which of course is the United States Supreme Court. And so here is the order from the highest court in New York, just a one-pager. Okay, they have a joke of a legal system there. The whole operation is just orchestrated to stop Trump because they've got no purpose in their lives. So they dropped this order, very short. Heather Davis wrote this. Dear Todd Blanche. Todd Blanche, remember, is coming into the Department of Justice, and he's going to have a nice position there. And they write to him, Mr. Blanche, Todd, your proposed order to show cause was reviewed by Judge Rivera, who declined to sign the order. And so as a result of the judge's determination, no motion is pending in the above title at the Court of Appeals. Very truly yours, Heather Davis. Copy to everybody. So it's the New York State Supreme Court, called the Court of Appeals there. They're just declining to get involved. So that is off the table. Now, all eggs are in the Supreme Court basket, and we're waiting to see what the Supreme Court does. Now, while the Supreme Court is contemplating this, and they just got all the filings that we'll read through today, and really Trump should have a response back, a reply back, but we'll see if that happens before tomorrow morning, or if there's an order that comes down from the court on when this should happen. Here is what Chad Pergram is reporting, and he's a correspondent for Fox News. He says a top Democrat on the House Judiciary Committee called Jamie Raskin, who was that dude on the illegal J6 committee, he wants Judge Alito to recuse himself from this decision because Judge Alito, and Politico and others are reporting this, had a conversation with President Trump about a law clerk and said, why don't you hire this law clerk in your administration or whatever, a nice phone call to get from a Supreme Court judge. And so Trump was theoretically considering it. So Raskin says, in our democracy that he tried to wreck, Americans expect their cases to be heard by impartial judges. Give me a break. Yeah, like, you mean the J6 judges? You mean like the DC judges, Jamie? This concept of impartiality goes back further than the court's own code of conduct and underlined the earliest versions of federal recusal statutes. A mere act of having a telephone conversation with the president-elect while he has active matters in interest currently pending is sufficient to trigger a situation where the judge's impartiality might reasonably be questioned. Hilarious. Apply that to any judge who handled any Trump case anywhere ever, other than Judge Cannon. Every federal judge and justice knows he or she must avoid situations like this, but Alito called him. And so they're trying to get Judge Alito recused. They want Trump's sentence so badly they can taste it. Jamie Raskin and the rest of the TDS bonanza, they can't help themselves. They've got nothing else to think about other than how they can wreck the incoming president who has been elected in overwhelming fashion, by the way. 7 out of 7 swing states all went in his favor. It was historic. And now they're like, well, you should be sentenced and called a felon because we want to just hit you over the head with that for the next 4 years. But we'll see what the Supreme Court does. It is on their desk. And let's take a quick look at what Alvin Bragg sent in. And now we're going to respond to this. Alvin Bragg is going to get the old backhand courtesy of our friends Ed Meese. And so here's what Bragg is saying. And if this is just a jurisdictional argument, okay, if Alvin's like, well, here's Supreme Court did legal, then that's going to be the most pathetic thing in the world. So let's see if that's inside of this. But here's what we've got. Via their introduction, we fast forward to that immediately. They tell us, Alvin Bragg, Trump is a defendant in a criminal action in New York. While he was a private citizen, okay, he was charged, tried, and convicted. Yeah, but the charges were based on conduct from when he was the president. All of the false business records that you allege in your case were signed in 2017. He was the president in 2017. So don't try to claim he's a private citizen when you're prosecuting him for presidential conduct. On May 30th, the jury found Trump guilty of all 34 felony counts. Only remaining step is sentencing. That's scheduled for January 10th, 9:30 tomorrow. At the sentencing hearing, the trial court already indicated he's going to put an unconditional discharge on him, which the people are in agreement with, we don't oppose, which is a sentence without any real penalties or any other condition upon his release. And once Trump is sentenced, in other words, they're saying there is no penalty that will be imposed upon him. And so therefore we can do it because they are recognizing, okay, they're kind of following the Supreme Court rule. So the Supreme Court came back and said, You can't impinge upon the institution of the presidency. That's a separation of powers problem and a supremacy clause problem. And so they're saying, okay, I guess we are adhering to that, but simultaneously denying that the rule exists. So we're not going to impinge upon him, but we're not infringing on the presidency. So they acknowledge the rule exists, but they're just choosing to only half follow it, which is why I think the Supreme Court's going to do something on this. Once sentenced, Trump then may appeal everything, including the erroneous admission of official acts evidence at trial. This is called immunity. And immunity, as has long been recognized everywhere, precludes you from having to face the consequences of the process, not just have after the fact appellate rights. Trump now asks this court to take the extraordinary step of intervening in a pending state criminal trial with scheduled sentencing before final judgment, and there's no basis for that. Bragg says, as a threshold matter, here we go, this court lacks jurisdiction. Oh, man, I don't think the Supreme Court's going to like that. Over a state court's management of an ongoing criminal trial when Trump has not exhausted his state law remedies. And he has now, by the way. There's been no final judgment or decree rendered. So they're going to say by the New York Court of Appeals or even the state trial court. So they're saying his case is not over, so he cannot appeal, which is just legally wrong. When he's making the immunity argument, you pause it and appeal it. And we've got evidence and precedent on that one. It's Judge Chutkan's case right next door in Washington, D.C., which is exactly what she did. You don't wait till the end. You pause it like she did. Lack of jurisdiction aside, this is pathetic. Trump has not satisfied the standards necessary to support the extraordinary remedy of another case. His assertion that any invocation of presidential immunity automatically entitles him to a stay is incorrect. This court must consider whether a stay is appropriate, talking to the Supreme Court. And Trump hasn't done that here. First, Trump claims that his recent election immediately entitles him to the same immunity, which is president-elect immunity, which would be a new concept since, of course, this hasn't happened before in America yet. Alvin Bragg and Merchan and Colangelo from Joe Biden's office, this is new. So the question is new. Does the president-elect have president-elect immunity? But that's not just what Trump is talking about. He's also talking about the official acts immunity that should have never come in during the trial. That is, Trump makes the there is no precedent. The unprecedented claim that temporary presidential immunity immunizes him now, weeks before he even takes the oath. This is an unprecedented case. That's why Trump is making an unprecedented claim. No other psychopaths have done this in American history, which is a crazy thing to think about. Like, think about all the lunatics that have been in positions of power in America. A lot. No one's done this before. This extraordinary immunity claim, which is a result from extraordinary criminal prosecution that is illegal, is unsupported by any decision from any court. It's like, yeah, I know. We know. You've never done this before. Thank you for proving our point. It is axiomatic that there is only one president at a time, but the Presidential Transition Act says that the president-elect is afforded a ton of benefits and that's by Congress, as they're coming in, because you can't just walk in on day one and have Joe Biden flip you the keys. Non-employees of the government do not exercise any official function that would be impaired by the conclusion of this criminal case. It's a private citizen for private conduct. This is like really actually not good. I think the Supreme Court is, come on, man. You charged him for conduct while he was the sitting president. And as this court has repeatedly recognized, immunity is strictly limited to the time that he's in office. And Trump also claims that the state court improperly admitted evidence, as we've talked about a lot here. But this type of claim, although ostensibly based on immunity, thank you for admitting that finally, does not support an interlocutory appeal. Yes, it does. The Supreme Court and even Chutkan acknowledged that. Because it is not an argument that the defendant is immune from suit. And they say it's unofficial conduct, so you can't claim that protection. His evidentiary claim also suffers from threshold issues and blah. And finally, the balance of the equities. Okay, so this is fair. So don't give them relief. There is a compelling public interest in proceeding to sentencing. We need to get him sentenced. The trial court has taken extraordinary steps to minimize any burdens on Trump. And the judge is even announcing his sentence, which is also, it's like judges announcing their sentence before they've even got sentencing memos from either side. There's not even enough time. Because Trump's, by law, I think he gets 10 days to review the sentencing memo from Alvin Bragg. How's he going to review the memo? There is no memo. And the sentencing is scheduled for Friday. So the judge is violating New York criminal procedure by accelerating all of this. So the judge is announcing his decision before he's seeing any evidence? Trump has provided no record to support his claims that his duties as president-elect foreclose him from virtually attending a sentencing that will take no more than an hour. Great, you admit it takes an hour of his time that can't be dedicated to other things. And it's a 1-hour hearing. You know how much time and energy his attorneys are spending on this case right now? He can't schedule his day tomorrow because he doesn't have to know if he's going to be on this dumb TDS sentencing event or if the Supreme Court's going to act. So his schedule is still in flux. That hour tomorrow could be very useful for a transitionary meeting as he takes office in 10 days. The current schedule is also entirely a function of Trump's repeated request to adjourn a sentencing date, and so we've already done that. So they give us their statement. We got the highlights of it. Let's just see what else is in here. As described, Trump and his co-conspirators, look, this is the Alvin Bragg criminal prosecution for false business records, 34 counts of a spreadsheet crime. But look how they phrased this. And this is why this stuff is so sneaky. And this is why people get skeptical about them, saying, well, what if they do indict him or sentence him? And then now he is a convicted felon. And this convicted felon, according to their statement of facts in the indictment, see, this is where it gets squirrely. They said, as established by evidence at trial, that Trump basically interfered and committed an insurrection in 2016, not 2020. Trump and his co-conspirators, this is Alvin Bragg, they want this statement of facts to be adjudicated and closed with a sentence so that on the record, the court of law found and sentenced that Trump did this. Co-conspirators orchestrated a scheme to interfere with 2016 by suppressing negative information that could damage his own campaign. They executed a scheme through a variety of means, including purchasing the right to extramarital affairs stories about Stormy Daniels, the porn star liar. Now, to the effect that this catch and kill scheme and Michael Cohen paid $130,000 to attain those rights, those were for a payoff, not for legal services. And so Trump then said that they were legal expenses and they weren't. So they're calling this essentially theft of an election. That's why they want this to stick, to say that Trump's 2016 victory was not legitimate, that he's been convicted feloniously of a scheme that stole the election. On April 15th, Trump's trial commenced with jury selection. Then the jury unanimously convicted him. Sentencing was originally scheduled, but it got postponed a bunch. Then they're going to get into jurisdiction stuff. The first federal removal proceeding, Trump tried to take it out into the federal court. They declined. The court said, nope, going back down to Mercan's courtroom. Then after the corrupt trial occurred, after the guilty verdict, and 10 days before the sentencing, the dispute was whether he could be prosecuted for his presidential conduct because the Supreme Court came back down and said there is presidential immunity. But then Judge Mercan turned around and said, I don't care. He wrote, the president, or this court wrote, the U.S. Supreme Court said, there are 3 buckets of immunity: absolute, presumptive, and no immunity. And so this court said that some things may be admissible and some other things may be inadmissible. And so then after that court came down, the Supreme Court, Trump said, you got to dismiss this verdict. On July 10th, Trump filed a motion to dismiss the indictment. He said that Alvin Bragg improperly influenced evidence and introduced it. He talked about Hope Hicks, Madeleine Westerhout, 2 White House employees, and convicted perjurer Michael Cohen. Then the motion was pending. Trump moved to adjourn the sentencing. Then he won the election. And then Mercan denied his motions. He says, no, you failed to preserve your objections, which was insane because Trump preserved his objections in multiple fashions. He argued it pre-trial, in writing, many times. Objection, immunity. The judge overruled it. He appealed those decisions. The New York Courts of Appeal denied him. He brought it up at trial, verbally, brought it up post-trial. The judge says, well, I didn't hear it. In any event, Bragg says, the court found that none of the challenged actions constituted core official actions, and none of it fell within the outer perimeter. And so therefore, Trump has no immunity at all. Then he filed the second notice of removal that also got denied from the Southern District of New York. Then after the trial was over, Trump submitted a motion to dismiss. The people told the court, Alvin Bragg, that they believed that we should have a sentencing. Then he filed another motion to dismiss, and more procedural history here. Then he went up to the New York State Appellate Division. They rejected him. And now we're here at the Supreme Court. And as it stands, all New York courts have rejected Trump's arguments. And so now it's up to the Supreme Court. And this is where these arguments, I think, this is where I'm not sure the Supreme Court's going to like this. They say, hey, Supreme Court, you don't even have any authority to hear this case. Okay, it's non-final. You can't hear it because you can only hear criminal cases when they've been properly adjudicated. Otherwise, you have no authority. What about when it's an immunity issue and you're in violation of the Supreme Court's prior case law? So here's what Bragg says. I don't think they're going to like this. As a threshold matter, you guys lack jurisdiction. You can't even hear this. There's been no final conclusion. Your review of state court decisions is limited. And here, there's not been a final judgment, and so you can't hear it. Also, this case doesn't present any limited set of circumstances. And these other cases that you've cited said that there has to be some other thing that pops up. Here, admission of official acts evidence is not dispositive at all. There's harmless error review. And so there is harmless error. And so you have no right to hear this because it doesn't rise to this level of being a limited set of situations that's outside of harmless error. So Trump has thus failed to exhaust his state court remedies. So he can't just bypass us and come directly to you. A full panel of the appellate division has not ruled on his stay. And Trump has plainly not obtained any appellate review on the merits from any New York court because they're not accepting it, Alvin. And so you can't hear this. And you also, Trump, he can't justify having the Supreme Court come in and intervene. We have to balance the equities here, Supreme Court, and you have to allow our case to proceed without intervening. This weighs in our favor. This court, the Supreme Court, has long recognized, don't intervene. And you've done that in other cases where you say, we're not going to intervene. And there's no risks with having this sentencing. Any stay here, if you delay the sentencing, well, we're in big trouble, court. If you postpone this sentencing until after Trump's inauguration, when he's inaugurated, his status as the sitting president will pose much more severe and potentially insuperable obstacles to sentencing and finality. Yeah, that's the point. He got elected. The people vetoed your criminal hack case. And now you guys are racing to get it done. So thus far from temporarily preserving the status quo, a stay would mean that we would delay his sentencing for years, okay? So their backup plan, their plan B, is to just hold on to the sentencing. Trump does 4 years as president, comes out, gets a prison sentence. And I guarantee you Khan is not going to come out and say, well, just give him probation at that point in time. 4 years later. And then now Trump is going to have this potential sentencing hanging over his head the entire term. Absolutely unacceptable. And the Supreme Court, I think, will agree. That result would be particularly inequitable here if Trump who was asked that sentencing, they're saying Trump already asked that this be postponed. And so we're just postponing it. Now we're just doing it immediately because we're out of time. And so we're actually doing this for Trump. And so don't reward Trump for delays caused by his own litigation choices. Okay, those litigation choices were legitimate, and you guys are in violation of those litigation choices. So is the entire state of New York, as they're about to find out, I think. On the other side of the ledger, Trump will face no prejudice. Okay, if we sentence Trump on January 10th, tomorrow at 9:30, the sentencing hearing itself will impose minimal burdens. Thank you for admitting that it is burdening the presidency. Thank you. You've just confirmed what the Supreme Court was concerned about that you're doing, because the state trial court has allowed him to appear virtually. Doesn't matter. It's still a burden. And in the people's experience, which is terrible, it would be feasible to complete sentencing in less than an hour. Thank you. That's a burden. You're admitting it's a 1 hour burden on a criminal sentencing. So you might call it minimal. I don't. 1 hour with the president-elect right now is the most valuable time in the world. In the world. In addition, the court has declared its intent to impose a sentence of unconditional discharge. So because we're not going to penalize you, we can do whatever we want. And we actually are even admitting that there is a burden on you, saying that Alvin Bragg does not oppose this, and it will prevent Trump from being subject to any ongoing criminal supervision. He's not going to have probation or somebody to check in on, no other obligations during his presidential term. The sentencing is not going to stop Trump from appealing anything. He can do that, including his claims of presidential immunity that he's asking for now. To the contrary, as soon as the sentencing's over, Trump, who's so upset about all this, can appeal. So we're doing it for him. Now, Trump is wrong to accuse Judge Merchan of acting with abruptness and extreme haste. Okay, why did you schedule it on the 3rd then for the 10th? 1 week later, 7 days on a Friday. A sentencing hearing more than 7 months after the guilty verdict is aberrational for New York. So is prosecuting the president. And if the ability of the appellate courts to conduct an interlocutory review has been truncated, that too was a result of his choices. He continued to complain about immunity and presidential-elect immunity. And so he kept delaying this. And so now we're running out of time. This is the only thing we can do is sentence him now. And the question of presidential immunity doesn't require an automatic stay. This court has never said that any invocation of immunity triggers an appellate stay. To the contrary, the court has recognized the need for interlocutory appeal principally where they're being sued for his official conduct. Okay, they're going to lose this because they're admitting it now. As long if a public official asserts official immunity, that's what Trump is doing. The dispute was over whether Trump could be criminally prosecuted for official acts. And in cases involving absolute or qualified immunity, can you stand trial for the consequences of official conduct? But here, Trump has conceded, they keep saying this, that the underlying criminal charges involved purely private and unofficial conduct that does not reflect in any way of his official duties, citing another case here. And they're taking that out of context. The evidence that was presented at trial was official acts. If they can prove this without any of that, let's see them try. They can't. The criminal proceeding thus does not implicate the legal question. Now, the advanced stage of this also distinguishes this case. We've already had a trial, and the rationale for staying this doesn't apply. The trial's already complete almost. We have to just sentence him. In qualified immunity, this court has been concerned that you're going to have to drag an immune person in, but this is already over. It's like, hey, as long as we violate your immunity rights and get you to a trial, the ends justify the means. No harm, no foul. I mean, it's already done, so we don't need to go back and have a problem with that. Here, however, the state trial concluded 7 months ago, and the entire criminal action is nearly completed. Only for sentencing. They're so close they can taste it. They can taste it. Defendant, as president-elect, will not face any discovery, trial, or extended proceedings. The only step is just 1 hour, one virtual hearing, an accommodation the trial court offered just to minimize his burden, just to make sure he can show up. And again, they're acknowledging there is a burden. Thank you. And Trump's stated concern about incarceration is illusory because the judge has stated its intent to not sentence him. But they cannot guarantee that. He could change his decision right then and there. And so there's a prospective penalty as well that you have to consider and plan for. And the threat, it's like the sword of Damocles hanging over your head. It could drop at any minute. Trump thus faces none of the burdens that have traditionally animated the need for interlocutory stays of proceedings. That's pathetic. They know damn well, so does the Supreme Court, that imposition of sentence is the whole point. It's the biggest point of the whole process. It's not done. That's why they're fighting so hard for it. Now, finally, this court has already held that federal rules of interlocutory appeals don't bind state courts, and they're free to deny a bunch of things. And so they're distinguishing these cases, but Trump's objections are misplaced. He acknowledges that, and New York law does provide other channels, and he is going up through the courts of appeals process, and they're rejecting him. And so he should be forced to go through the New York process. And now Trump claiming president-elect immunity does not warrant this court's intervention. No judicial sentence or guidance from the DOJ has ever said that there's president-elect immunity, because it's never come up, because lunatics like Bragg and Fannie and Jack Smith in 234 years never did this. Then Trump came along, and he's so effective that they had to break glass in case of emergency and try to wreck American justice in the process. Such an extension would conflict with the court's holdings. The president-elect doesn't perform any constitutional functions, and so he cannot be protected. If you recognize president-elect immunity, that would be inconsistent with other things, and Trump's assertion disregards the limited concept of presidential immunity, that it has a durational feature that ends at the end of the presidency. Now, although Trump relies on this congressional act called the Presidential Transition Act, the limited authority there cannot deem any of his conduct official or unofficial. And to the extent that Trump isn't raising other empirical claims that the transition is too onerous to make time for even a brief virtual sentencing, Trump has failed to establish that on the record. There's also reason to doubt that. The court has previously recognized that his duties are not so unremitting as to make him compliant with the subpoena, and so it's not that big of a burden. And so he can't even claim that is a burden. So you can not stay this and allow him to be sentenced. His objections also are mismatched. Bragg says Trump asserts that presidential immunity precluded certain evidence from coming in. But we already admitted it. It was already admitted. And no stay can unwind that admission. Wow, I can't believe they wrote that. We were just mocking them earlier. Like, as long as we break and violate your rights, as long as we get it done, then we're good. No stay can unwind the admission, right? We already did it, so there's nothing you can do about it, so just eat it. Now, the sentencing will not involve any introduction of evidence at all. All he has to do is just show up and get lectured by Merchan. Nor is a stay necessary to preserve his ability to challenge the use of evidence. He can raise all those on appeal after the case is closed. Even if this court were to consider his evidence now, you would not grant certiorari because the court has harmless error. None of this stuff results in any consequences. It's all harmless error, even though we're talking about the president-elect 10 days before his inauguration. And Trump's failure to preserve objections, which is a total lie. They were preserved many times to Merchan's face, right to his face. And he's still like, what did you say? After carefully examining the evidence, the state court concluded that any official act's evidence was harmless error. And we'll see if the Supreme Court creates that new standard and says, oh, okay, that's interesting. You invented that. Harmless error on official acts immunity questions? Where'd that come from? Oh, Merchan's booty. That's right. Trump argues that the trial court erroneously admitted a bunch of evidence. Hope Hicks' testimony, Madeleine Westerhout, X account post, Michael Cohen and his lies, testimony from Cohen's about the FEC, public disclosure documents, and more. Here, they say, you can set aside, a court may not set aside in New York based on alleged errors that were not properly preserved. So Trump didn't raise immunity properly, is what they're saying. So this is pathetic. It's a lack of jurisdiction. Lecturing the Supreme Court, you cannot hear this case, even though we're in direct violation of your order in the Trump case. And then now simultaneously, lack of preservation. Pathetic. Certiorari would not be warranted. Trump relies on this court's holding that official conduct that for which the president is immune may not be introduced at trial. And we didn't do that, they say. Trump talks about these two categories, but the evidence of Trump's conduct may be admitted if it is unofficial or it's been rebutted or the evidence consists of a public record. And we've done that. He objected to his tweets and more. And they say, look, these tweets are not public comments. And we've seen a lot of this analysis before. Oh, Trump's tweets are not public comments. They're more like personal comments. Even if the tweets were official acts for which they would be immune, they would be admissible because they're just a simple public record. And we can use other public records exception to immune conduct. The immunity protects the person against the charge. You don't get another independent discovery doctrine or something like that. So he's talking about admissibility, essentially. We're admitting them as a public record. We're not admitting them as some other official act of the president. This is so dumb. Now, nor was there any other error in the admission of Hope Hicks or Westerhout. The only testimony that they elicited from Hicks related only to unofficial conduct, which was the discussion about the hush money scheme and the president's reputation and official communications to protect the institution of the presidency are clearly official business. Now, as to other post-trial objections, the description of this evidence involving details and how she handled private affairs, all of that was unofficial conduct. He can't even claim immunity for it. And so his arguments are invalid. They also challenged Michael Cohen. But evidence from Cohen is unofficial because it involved the cover-up. They're private parties. They weren't acting in any official capacity. And there was no hearing on any of this, right? The judge just decided this. Trump argues that Cohen's testimony is talking explicitly about what Trump was doing in the presidency. But they said, well, because Cohen lied, in my opinion, and said that all of this was about a scheme, that Trump cannot object to that evidence coming in. And finally, the form. They say all the evidence that Trump challenged is unofficial. There is no immunity there. Trump can raise his evidence at appeal, but as it stands right now, the Supreme Court should deny the emergency application from Alvin Bragg, written by Stephen Wu from the Chief Appeals Division. And it's pretty bad, pretty pathetic. I had an inkling or a feeling in my gut without any real substance behind it that the Supreme Court is going to step in and do something on this. And after reading this response, I'm even more of that opinion because their arguments essentially are jurisdiction and preservation. The Supreme Court can't hear this case because New York, in their hack legal silo, can do whatever they want, even if it is impinging on immunity. And then the second is preservation. Like Trump didn't preserve immunity claims? Yeah, he did. We read a bunch of them here on the show multiple times. And the judge didn't do what Judge Chutkan should have done. So now this is working its way up through the Supreme Court. We've also got this brief of legal scholars, okay, who are all now going to be supporting Trump being sentenced. And so we're not going to read this. I just wanted to show you who these people were. Ty Cobb, remember him? He's that weirdo who shows up on CNN. David, Donald Ayer, Tom Coleman, bunch of people. Bill Kristol, oh gosh, he signed this. Chief of Staff to Dan Quayle, total loser. Who else? Shane, Claudia, Shay, a lot of these people, most of these people don't even recognize or have any idea who they are, but they're all piling in. We want Trump sentenced. He must be convicted. And they're dying to make that happen. Now, actual smart people who we've talked about here before are known as Edwin Meese, former Attorney General, and Professor Stephen G. Calabresi, are intelligent folks who've actually constructed an argument, and they just need two of them. They don't need 50 people who just sign their names to a dumb letter to make them feel like they've done something important. Will you sign our letter? Who else signed it? Okay, if he signed it, I'll sign it. Pathetic. These two guys just drafted this. Here's what they said. All right, listen. Supreme Court, you got to hear what we're talking about here because we've been right before. We got Jack Smith thrown on his booty. And here's what we're telling you now. All right, Supreme Court, this continued prosecution of President Trump violates core constitutional principles long recognized by the DOJ, which issues opinions on behalf of the AG that are the formal legal opinion of the federal government, and they're binding. The OLC has issued 3 opinions, by the way, 72, 2024, that talk about prosecuting a sitting president. And under the OLC's consistent view, given President Trump's imminent return to the White House, presidential immunity requires that the prosecution brought against him by Alvin Bragg must be dismissed and the jury verdict vacated. Trump's request for a stay, Supreme Court, is therefore well-grounded. Here's why. The Office of Legal Counsel holds that the Constitution forbids a sitting president being indicted or prosecuting, granting him unique immunity. This immunity arises from the separation of powers at the federal level, and it exists at the state level because of federalism and comity rooted in the Supremacy Clause. It extends to all stages of criminal proceedings, all of them, including sentencing and appeals. criminal prosecutions are different than civil because there's a great burden they impose, like you go to prison. Although a particular prosecution might not burden the president to an unconstitutional extent, the lack of certainty ex ante on that score necessitates a categorical rule against indictment and prosecution, meaning you cannot do this on a case-by-case basis. We don't decide individually whether Fannie's case is going to be good or bad for the president, or whether Bragg's case is going to be good or bad for the president, or whether anyone else's who would be prosecuting a Biden or an Obama, or whether, which has never happened, by the way. But if they did, would they have the ability to make a discretionary decision in their brains about whether this was legitimate or not? Answer, no. That's not part of the process. The people elected this person. You don't get to come by and be a hack prosecutor to prosecute them. The scope and gravity of the president's duties are such that the practical demands of the presidency are all-consuming. And the risk that the stigma of attending criminal proceedings would impair his performance is intolerable under the Constitution. And so given that, it is unsurprising that the OLC recently concluded that the Constitution does not even permit a prosecution to be held in abeyance during the president's term. So Merchan and Bragg's efforts, once the Supreme Court stays this, to delay this beyond Trump's term, not allowed. Otherwise, they have leverage over the president, which would be an insane thing to allow to happen. Presidential immunity extends to the outer perimeter of his responsibilities, and so a categorical rule captures the concept of core immunity. Now, even if the Constitution did not definitively require a dismissal of this case and sentencing, prudence counsels it. Now, while a state does have legitimate interest in criminal prosecutions, and it has a sovereign right to go after criminals and more, the United States also has a compelling public interest. We want the sitting president to focus on his duties, unburdened by what has been and undistracted by ongoing prosecutions. Trump is already engaged in official duties as the president-elect, and besmirching his standing as he performs those duties would be noxious to the Constitution, almost as noxious as Fannie. No president can be impaired in that fashion by a county prosecutor. Even if the charges were well-founded and continued prosecution consistent with the Constitution, New York and their state interest in a single criminal case is dwarfed. The whole country just spoke. The whole nation says, you lose. He's our president. So you're not prosecuting our president. It's your country too, morons. Given their interest in and demonstrated commitment to the rule of law, the immunity issue this brief addresses is particularly important. As you know, Ed Meese, 75th AG of the United States, to Ronald Reagan, and Calabresi is one of the foremost scholars, an actual scholar, advised Ed Meese during his time in office, and they agree with Trump. Here's why. Consistent with Article 2 of the Constitution, attorneys generals have provided legal opinions to the president since the Judiciary Act of 1789. Now, the Attorney General delegated that function to the Assistant AG, and many people issue opinions, and we've done that 3 times in America. Here's what their titles are: 73, 2000, and more. Although the OLC is nonpartisan, it is noteworthy that the 1973 opinion came out under Republicans, the 2000 opinion came out under Democrats, Reno, Elliot Richardson under Nixon, Reno under Clinton, and then the current OLC reaffirmed these things. So you could say it's bipartisan. Some Republicans, some Democrats. And so these opinions represent longstanding, quote, nonpartisan and bipartisan view on what the DOJ can do when it comes to presidential immunity and sitting presidents. And we'll talk about it right now. Here's what they explain. Under their view, with Trump's imminent ascension to the presidency, immunity requires dismissal of the Bragg prosecution. No sentencing can happen. The opinion, and notwithstanding that opinion, the trial court, through Merchan, they wrote, look, you can't prosecute someone. They're going to try to wound the president. It's going to hamstring the operation of the whole governmental apparatus, both in foreign and domestic affairs. Alvin Bragg, Judge Merchan, and the New York Court appellate judges are all trying to knife Trump in the back, like in that scene in Gladiator at the end, right? Knife him in the back to give him a wounded appearance as he emerges. This is our own country. This is our own president. You might hate the man, but he's got 4 years in office. And now they want to wound him. The OLC says, you can't do that, you lunatics. But they don't care. Merchan said, well, whatever threat of public stigma is from this, it might have existed. It's long past, all right? It's long past. Yeah, right. Why are you so interested in sentencing him so badly then, Judge? Why do you want it to get done so quickly? Because of the stigma. It's the only thing you care about. It also concluded that Jack Smith had to end his prosecutions, okay? Even Jack Smith dismissed his cases. They say, well, it's not going to apply to us because we're a state. But that's not right. 3 opinions from the Department of Justice all say the opposite. Under department precedent, you cannot prosecute a sitting president. For 52 years, the department's position has been the president is uniquely immune from any of this. The latter is significant too, saying he's immune from indictment, because an indictment must be brought before the statute of limitations runs. Therefore, a president's immunity from indictment is immunity from being placed under the shadow of prosecution. And it's violated even if by pending charges, even if those charges are not being actively pursued. And that prohibition goes to both the feds and the state. It's a separation of powers problem at the federal level. The latter is between federalism and comity and supremacy. Just as this court enjoys a balancing test, courts must balance federal interest against state interests. In the case of a president, either a sitting or former president, who at the time of trial was the presumptive opposition party nominee, that rises to a constitutionally perilous situation. You cannot, it is impossible to impanel a neutral jury, especially in New York, that's 70 to 80% blue voting for Kamala. The department noted the passions and exposures about somebody running the most important office in the world are such that the American people are unlikely to have faith in the impartiality and the sound judgment of 12 jurors who that now are judging for 340 million Americans. Those 12 New Yorkers who are probably riddled with TDS, and those who weren't were scolded like only the left can, with spittle flying out of their mouth. You're not going to acquit an insurrectionist, are you? Could you even imagine what it's like in that room? Stinky, too. So those 12 jurors are then going to decide for all of America? No, America decided, and we've decided Trump is our president. And so our country is not going to prosecute our president anymore. The department's constitutional analysis covers all criminal proceedings, whether they're official or unofficial wrongdoing, in quotes from the OLC memo. In all cases, the inquiry is this going to impede the presidential functions? And it obviously is. And they even admit it. It's already imposing burdens on him. The burden imposed by a criminal prosecution is so much more profound than a civil action, because it's even if incarceration's off or on the table, it's still a burden. They even call this out. Once charges are filed, the burdens of responding to those charges are different in kind and far greater degree. And the Constitution doesn't allow that threat. There's a threat that Trump goes to prison. It exists. The judge says he's not going to do that, but we don't trust this judge because he's dishonest and a liar, in my opinion. Somebody who has to gag people from telling the truth about who he is. And he says he's not conflicted or biased, even though he made 3 donations, I believe, maybe 2, against Trump. Clearly biased. Doesn't even have the good sense or judgment to recognize his own perversions. They say the prohibition extends to the unusual circumstances of a prosecution of a sitting president that's also held in abeyance. So you're not going to hold this sentencing over his head for 4 years. Don't even think about it. This follows because the presidency is all-consuming. Even the OLC says that the duties of the president are very demanding. They are, in fact, enormous. President Washington, number 1, wrote that the duties of my office at all times, unremitting attention. In the 2 centuries since the Washington administration, the demands of the government have grown exponentially. Cleaned up that comment which was another observation in a prior case. They say the president does a lot. He's the commander-in-chief, national security, intelligence, daily brief. He needs his mind undivided. The role is literally life and death for everyone. Includes being fully present when catastrophic events happen, like 9/11 and more. The commander-in-chief must defend against existential threats and commands the nuclear arsenal. They're also the chief executive. They're the head of ceremony. As the chief diplomat, chief executive, commander-in-chief, everything. Also has an inexhaustible list of domestic duties. The Constitution has a take care clause, faithfully execute. President must fulfill and replenish 4,000 political appointments. Has to address the nation. Handles multiple departments. His days are never ending. He's on duty 24 hours a day, 365 days a year. 340 million people rely on this person. The American people cannot afford their president being preoccupied with a prosecution that would interfere with his duties. And the department even acknowledges this. The department added, the spectacle of an indicted president still trying to serve as chief executive boggles the imagination. And so the department concluded the president cannot be unduly burdened by an indictment after he leaves office. And they explain in multiple locations this would interfere with the president's duties. And even public stigma and opprobrium is enough. That stigma alone could compromise the ability to do their jobs. Now, the rest of the world is going to be like, oh, America prosecuted their own president. Great. Now, while the department spoke of this burden arising from the initiation of criminal proceedings, the stigma only comes at the beginning, not at the end when it becomes final and clear and finally adjudicated. Any such opprobrium, they say, does not only attach once an indictment is handed down, it persists, it's ongoing. This is the final moment. The clock is about to expire on this case. What is the scoreboard? Is it conviction or not? It is the only thing that really matters in the end. Other burdens are mental, they're physical. They could hamper the president's performance. They're going to take an hour plus out of his day. Trump's going to have to prepare for his sentencing, and they're going to have conversations about it. He's not just showing up on a Zoom call. Oh, it's the judge. That burden must be assessed in light of everything. And the court also noted that the president is unlike a lot of other people, and is like many other people, in fact, can become distracted or preoccupied. And criminal prosecutions are much worse. So the conclusion here from the OLC is that stigma from the prosecution at any stage, not just the beginning, is severely damaging to the president's credibility and to his national standing, and it would interfere with his ability to do his job. Now, current AG Garland is continuing to adhere to this position. The Constitution requires dismissal. They dismissed the J6 case, and we saw Jack Smith do that. So then we're asking whether they can hold this in abeyance and whether the president can be punished after his term. They say another case cabinet's holding, talking about subpoenas and other things. The Vance case also talked about subpoenas. But in short, when you summarize all that, this Supreme Court has instructed that the high respect that is owed to the chief executive should inform the conduct of the entire proceeding, which would include the appellate phase. And so all that means you've got to terminate the prosecution here. And even if the Constitution doesn't require a dismissal, if the Constitution doesn't require it, you should just do it. Prudence is in favor of dismissing this case. Even if these constitutional violations did not require dismissal, prudential principles heavily weigh in favor of this. It's in the nation's interest. In times of peace or war or prosperity, the president has an unparalleled role, and we shouldn't be hampering him. The states do have a legitimate interest, but the conflict here has been misjudged. Yep, New York has an interest in prosecution. Yeah, no man is above the law. We've heard that phrase repeatedly. Unless you're Donald Trump, then you're way below the law. You're gagged. Your house is raided. You have illegal prosecutors who are appointed. You've got $50 million of public funds that are absconded, stolen from the public to prosecute you. So Trump is far below the law. And that is how the court should categorize these interests. Now, to be sure, Bragg says the public interest is compelling. But his authority that he cited is not persuasive. His argument thus proves too much. His sweeping claim would mean that every single criminal prosecution vindicates a compelling interest, and that goes too far. By contrast, there is truly a compelling public interest in an optimally functioning president. And America's bigger than New York. As such, even when the Constitution does not definitively command exemptions for the commander-in-chief, courts should consider what they're doing here. It's imperative to furnish the president with the tools to do his job. And prosecution by Alvin, who is also a political opponent, cast in stark relief, a threat to the president's job. This is a vulnerability. The president never sleeps. He must be ready at a moment's notice. And so now he's being impinged by Alvin. And another Clinton case will distinguish here. And as the court has reasoned, when you're balancing these interests, no one doubts that Article 2 guarantees the independence of the executive branch. As the head of that branch, the president is unique. His duties are a lot. And you've got to be able to safeguard the president's ability to do his job. Those who've served in White House positions understand how serious it is. And to grapple with an ongoing prosecution while you're trying to lead the country would be unthinkable. The nation would suffer. And New York, your interest is dwarfed by the nation as a whole. The court has ruled in favor of national interest against a lot of other state interests before. As Jack Smith even explained in D.C., Jack Smith said it. He dismissed the case against Trump. He said the Office of Legal Counsel concluded, because a pending prosecution would impair the president's ability to do his job to the detriment of the nation, the constitutional interest in his unfettered performance of his duties must take precedence over the immediate enforcement of the criminal law against the sitting president. Even Jack Smith admits it, which is the right analysis. Now, we're not saying that Jack Smith is like a good person. He's like, well, I'm going to follow the law all of a sudden. No, he dismissed the case and stopped the prosecution so he could write his report. That's all. He needed to wind this up and write his report. He's trying to get that out. We're going to come back on that one in a minute. Now, this is despite the fact that the OLC opinions recognize that the critical national interest is upholding the law and even that the president is not above it, right? Can't prosecute him. So Ed Meese and Calabresi, they say, even though a former president can be subject to criminal prosecution, there can be no initiation while he is in office. The sitting president may only be charged after the completion of the term. And so therefore, Bragg is thus incorrect that this court, Supreme Court, has consistently allowed the criminal process to go forward during a sitting president's term. In the facts from Nixon that Bragg brought up, the sitting president was an unindicted co-conspirator for which the criminal subpoena was not part of his prosecution. Can you read? Same thing in Vance, Bragg. The president can be investigated and can be required to comply with criminal subpoenas, but the president cannot be under indictment or prosecuted, as is happening here. Now, the burden here is not distraction of the investigation alone, nor further or future criminal liability. The finality of the judgment is the penalty. And there's no justification for that here. They're going to finalize and preserve a conviction of a sitting president? What? That's their end game? That's the goal, is to create a stigma and a suspicion and to tarnish the president of the whole country. That is one reason that AGs of the United States have long held that public interest in criminal prosecutions must give way to the presidency. In fact, if you go back to 1818, Attorney General called Wirt advised President Monroe. He said, a subpoena ad testificandum may be served on the president of the U.S. if the presence of the chief magistrate be required at the seat of government by his official duties. I think those duties paramount to any claim which an individual can have upon him, and that his personal attendance in court from which the summons proceeds ought to be and must of necessity be dispensed with. Even important state interests must give way to the feds. It's called the Supremacy Clause. We're familiar with it. And Congress certified Trump's election on January 6th. He's picking his cabinet. Pam Bondi is going to be here for her confirmation hearing next week, the 15th and the 16th. We're going to be live streaming all of that, so please join us. He has received emissaries and is negotiating. We're taking over Canada. We're solving the Ukraine war. We're calming Putin down. Trump is also busy drafting orders that he's going to sign in 11 days. It's intolerable that one county prosecutor in one state could besmirch a president's reputation and reduce his effectiveness in carrying out his extensive duties at this time. And so, on behalf of Trump, they round this out. They say, indeed, the issue of whether one state on its own can burden a federal official was already decided in an earlier case, where Chief Justice Marshall held in the second half of his legendary opinion that Maryland could not tax a branch of the Bank of the United States differently than all other banks doing business in Maryland as they were being taxed at that time. He said, singling out a federal office or instrumentality for a unique burden would be a power to destroy that itself, and that is preempted by the Constitution. Today, there are 50 states, 2,300 county prosecutors. Some of them are quite partisan. Talking to you, Fanny and Alvin. This court should not allow one of them to interfere and impair the president's duties or the congressionally certified president-elect's duties. The Constitution preempts this. The OLC said the same. Criminal litigation requires president's personal time and energy, and it will require mental preoccupation. And so it cannot be allowed. In applying those principles, all courts must be mindful that the interests that underlie presidential immunity seek to protect not the president himself, but the institution of the presidency. So it should extend to the president-elect. So Ed Meese and Calabresi say, for these reasons, if the New York Court of Appeals denies a stay, and they have, or if it becomes evident that the Court of Appeals will not grant a stay, the court should grant the application for a stay of sentencing pending Trump's interlocutory appeal claiming presidential immunity, signed by the attorneys on behalf of Ed Meese. This is Gene Scherer, Jessica Hart Steinman, on behalf of Ed Meese and James Calabresi. So another very good opinion there that is protecting the institution of the presidency and articulating why Alvin Bragg's sentencing should be stayed. Okay, these are bitter people. Their only end game is to get a conviction, and they're trying to fake themselves to say that this is not a legitimate, or this is not a serious burden. If it's not a burden, then what is your interest in it? Finality? You just want to complete the paperwork like you have an open form on your desk? Why are you racing to get it done? Because you know there's going to be a stigma. You want that factual basis to be incorporated into the filing. And so this is at the desk of the Supreme Court. And let's do a refresh to see if there was anything else that is dropping before we round this segment out. And nothing has hit yet. And so we are now after the 5 o'clock hour on the East Coast by quite a bit. So we're not seeing anything on the SCOTUS docket. Trump's sentencing is scheduled 9:30 Eastern time tomorrow. Likely that we're going to get something before then. And if I had to predict, I don't think the sentencing is going to happen. So we're going to keep our eye on this. We're going to see what the SCOTUS says. We're going to be here tomorrow morning, regardless, I think, because the Supreme Court also has oral arguments tomorrow on the TikTok case. So we're going to be piecing together what's happening with sentencing. Thanks for subscribing and joining as we do. All right, now we're not done yet. Let's see what's happening in Florida, and then we're going to hear from you because we got to talk a little bit about this Jack Smith stuff, which is also percolating in the Court of Appeals because they really want that report to come out, and we'll see if that happens or not. But here we are on this one. Jack Smith continues to fight to get his report released. We know that his cases are both dismissed. We know that he was rejected by Judge Cannon for being an illegitimate prosecutor who stole $30 to $50 million in order to prosecute Trump from illegal appropriations. But now Trump's defense is demanding that the report not be released because Jack Smith is illegitimate. He should have never had access to the grand jury materials or seen any of these bits of evidence at all since he's not a real prosecutor. So we saw that Walt and Carlos submitted their filings into the 11th Circuit because this is now up on appeal. Judge Cannon said, you cannot release the report at all. They came back and said, well, we're going to bifurcate this and release volume 1, but not release volume 2. And that's not how she separated it out. She called it the final report, which includes all the volumes. So now they're appealing it and they're making their position heard. They're waiting for the 11th Circuit to come back down. But this is the brief of Trump, President Trump himself. Yesterday, we just heard from the other attorneys, and this came out as amicus curiae. Trump is not on this case anymore because it was dismissed, because Jack Smith dismissed the J6 case and the classified documents appeal as it relates to Trump, because Trump is now the president. And as we just saw from the OLC, they will not prosecute the president. So now the question is, will the report come out? And what we've seen here is more activity, an amicus brief filed by Trump, and this came down after the 11th Circuit granted him permission to do it. So he said, may I file this? They said, yes, you can. Here is what the order looks like. Order from Dave Smith, clerk of the 11th Circuit, says motion for leave to grant amicus, to file an amicus brief is now granted. So Trump has permission to do it, and he has now done it. See these names? Emil Bove is on here. He's going to the Attorney General's office at the DOJ. And we're excited about that. They certify it. They give us their table of contents. And this is what President Trump says in order to stop the release of the report. All right, 11th Circuit. President Trump now files this brief as amicus curiae, a friend of the court, in support of Walt Nauta and Carlos de Oliveira. And so they're helping each other. Yesterday, Walt and Carlos were like, hey, we're still being prosecuted, so you can't release this public report against us since you're still prosecuting us. And Jack Smith is kicking himself for adding them as co-defendants right now. He's like, oh man, I shouldn't have done that. I'm dumb. Yeah. Now, like them, Trump is subject to the final report. And the final report was inclusive of both of those volumes, which we appreciate Judge Cannon doing. Indeed, he has been the target of Smith, who brought two prosecutions against him, the election case and this one, both of which were unconstitutional and constitutionally suspect from the start. Now, as the district court, Judge Cannon, properly concluded here, Jack Smith is not a real boy. He was unconstitutionally appointed and funded, illegal. Moreover, the election case unconstitutionally relied on immune presidential acts. And how do we know that? Because Jack Smith had to file a superseding indictment, a second draft of his criminal charges. And in the second draft, he got rid of a bunch of the immune conduct. Fortunately, the American people roundly rejected Jack Smith's unlawful prosecution of the president. And on November 5th, we resoundingly elected President Trump to be the 47th president of the United States again. Now, as president-elect and soon to be number 47, Trump has an interest in smooth transition and an efficacious vesting of the executive power. There is thus more than a little irony in Jack Smith's and Garland's attempt to release the final report. The report is nothing less than another attempted political hit job, which sole purpose is to disrupt the transition and to undermine Trump's exercise of executive power. Some might call it interference with the peaceful transition. Attempting to publish the final report evidences complete disregard for Judge Cannon, which found that Smith is unconstitutionally appointed and funded, and he has no money to even write the words on the page. Instead of respecting that ruling, though, Garland is now seeking to defy the district court by publishing the final report in a manner inconsistent with the rule of law and the principles of constitutional governance, and this 11th Circuit should reject this attempt now. Here's why. Garland cannot issue a report of an unconstitutionally appointed and funded and illegal, not a real boy, Jack Smith. He cannot do it. Why? Jack Smith is invalidly appointed. The regulations that authorized his appointment are unconstitutional and thereby void. That the district court reached a contrary conclusion is of no moment. I don't care if Judge Chutkan loves Jack Smith. The D.C. court was bound by distinguishable D.C. Circuit precedent that applied Nixon in an unpersuasive fashion. She had no choice. The precedent she's relying on is terrible. And the district court here, Judge Cannon in Florida, is not bound by that holding. And it explained why the D.C. precedent is wrong. That's why we have a beautiful system with separate circuits. Now, the district court's analysis vitiates the entire regulatory apparatus involving Jack Smith, which includes Garland's ability to appoint Jack, Jack's authority to compile and transmit a report, and Garland's authority to release the report. Judge Cannon already obliterated all of it. There is therefore no authority at all for Smith to do anything that he did. The acts of all federal officers must be justified by some law. They can't just do whatever they want. And in case an official violates the law to the injury of someone else, the courts have jurisdiction to grant relief on that. And so that's why we're here. Indeed, Congress has expressly approved such a remedy for final agency acts like the appointment order. And that's what Trump is doing here. His requested relief is therefore not just part of this court's general equitable authority. You have constitutional power too, congressional power rather. And this question has come up. What if Garland could have hired Smith as an employee? They say, we don't care. It's irrelevant. He's not an employee. You appointed him as a special counsel. The fact is, he didn't do that. The government cannot now attempt to justify Smith's appointment in this post hoc manner after the fact, say, well, we just think about it like we did hire him as an employee. You didn't, though. The government's analogy between Smith and a federal employee fails. This case is far afield from Buckley versus Vallejo, which is what the government cites. The Supreme Court has even since limited that case to its own facts and held that the proper remedy for a successful appointments clause challenge is voiding the putative official's acts. It's all void. And so the government also claims an unbound authority for Garland to publish this material. Why? But publication in this context is simply an extension of Jack's unconstitutional appointment and his illegal money. The regulation authorizing the public release do not let Garland alter what Smith says. He only decides whether to publish it or to report it publicly. He is just a mouthpiece for the unconstitutionally appointed Jack Smith. And furthermore, because the special counsel regulations that Garland signed are void, and because that is the authority the government says Garland has to publish this report, he cannot do it. In spirit, if not the letter, Garland's release of the report would be akin to avoiding a judicial decree by carrying out the prohibited acts through aiders and abettors. At a minimum, so Jack Smith is illegitimate, but if he just gives it to Garland, Garland can just release it now? Well, I'm not releasing it, Garland is. What? At minimum, respect for the conclusions of a federal judge, Judge Cannon, that the appointment and funding of Smith are unlawful, those should have made Garland at least pause before he plows ahead to release this thing. But Garland now cannot simply publish a report prepared by anyone. For one, he needs statutory authorization to do it. Look at this case from 2022. And the government's claims that a generic authorization statute gives him permission is insufficient. Here's this other case from 24. It's the Chevron case, Loper-Bright. Moreover, there are statutes barring the release of information also identifying individuals or grand jury material. All of that is going to be bound up in the final report. And so for the same reasons, the Appropriations Clause also requires relief. The Appropriations Clause violation comes from the Appointments Clause violation since they both are invalid. He was illegally appointed and then took a bunch of money via his illegal appointment. And so if you issue this final report, it's going to violate the Executive Vesting Clause, it's going to violate the Presidential Transition Act, and it's going to ensure an orderly and smooth transition of power. Which is intended to ensure a smooth, orderly transition. The report will meddle with that. Congress intended the act to create a smooth transition. Releasing a report wouldn't do that. Congress was wise, okay? The transition period is sensitive. And the final report promises in a way to interfere. The indictment threatens public stigma and opprobrium, and all of that could compromise the president's ability to do their job. Now, that is a burden, and it needs to be protected. The final report is no different. Just like an indictment, it wrongly alleges that Trump and others committed crimes. In fact, it's even worse. The final report goes into more detail about the alleged crimes that others supposedly committed, and it involves evidence that was never released to the public at all. Indeed, evidence that could not be released, such as those involving official acts for which he could not be prosecuted. And moreover, the final report is one-sided. It makes no effort to point out the shortcomings in the evidence, no defenses, no explanations at all. All they claim is criminal. And significantly, unlike a court filing or traditional process, Trump cannot respond to any of it except through his own statements, and without the use of any evidence to support his claim, because he's got a protective order on him. So he can't share the evidence. Jack Smith can write this giant report, but Trump can't. So in sum, the public release of the final report threatens the same, if not even more, stigma than an indictment, and represents an equal, if not greater, infringement on the exercise of executive power, completely disregards the transition. Public release is contrary to the Constitution and to the law. The government's contention that the final report is consistent with an orderly transition is unsupported ipse dixit. You are sure right about that. It is ipse dixit, isn't it? President Trump says otherwise. As the president-elect overseeing the transition, his views on the subject are worth considerably more than the convenient litigating positions of the government. And I guess we should pause and look up ipse dixit and see what that means. Now, that's a fun one. As the president, unsupported ipse dixit. And we're waiting for this to load up and give us some facts on this. I don't know what it means. Ipse dixit. Latin phrase. He himself said it. It refers to an assertion made without supporting evidence, relying solely. Okay, so it's like you're just sniffing your own glue a little bit there. Unsupported ipse dixit. Like, I said it, so therefore it's true. Now, we don't think that's how that works. Thus, the government tries to duck the issue, suggesting that defendants lack standing to raise it. But defendants would be injured by the issuance of the final report. In separation of powers challenges like this one, it is sufficient that the challenger sustains an injury. And so Trump's participation allays any prudential concerns. And so in conclusion here, you should block the release of this entire final report, not just volume 2. The court should stop everything in toto. As in volume 1, the government arguments that their injury here is limited to volume 2, so we'll just withhold volume 2. But the government ignores the fact that the volumes cross-reference each other. They're not siloed. The government promises injury by distributing volume 2 to members of Congress, by the way. There's no way to stop those members from leaking the complete report, especially to attack Trump. You guys leak everything. So the premise that injury only arises out of volume 2 is also just wrong. Walt and De Oliveira had been linked to the president via Jack Smith from being called co-conspirators in the superseding indictment and other references in the press. The government cannot do unstatements from the last couple of years linking all this together. A slanted report is going to have collateral effects on them, and their case is still pending. Even if the court decides some portion of the final report could, despite Smith's unconstitutional appointment and funding, be made public, it should maintain the district court's temporary restraining order and direct the court to review the final report and verify the claims about the manner in which the report was prepared and transmitted. The district court could then fashion with the benefit of having reviewed the final report and with briefing from both parties. And so again, it's like another, just don't release it right now. Just send it back. If you think some of it might be releasable, just don't allow it now. Send it back down to Canon, let her review it, and then we can come to a timeline accordingly. So again, more delay tactics, which are very appropriate at this point. It feels to me like this, from Trump's defense, is a little bit less solid in a way. Like they almost are knowing that maybe some portion of this report will be released because Jack Smith probably has some cover in the DC circuit and that precedent. And that precedent is not as solid as the immunity precedent that we've seen in the Alvin Bragg prosecution. So we'll see where this one goes. I feel like the 11th Circuit might release or allow some documents to come out, but I hope I'm wrong on that. I do think that the Supreme Court steps in on sentencing on this one. I'm less confident. But Jack Smith is illegal and not a real boy. But he's got the benefit of the DC Circuit saying he is a real boy. And so will the 11th Circuit gobble up Volume 1 into Volume 2? We'll see. We'll keep our eye on this one. 11th Circuit's going to be issuing a ruling. The clock is ticking on this one as well, because when Trump comes in, he is now in charge of the Attorney General's office, and then he can override his Attorney General on releasing the report. So the clock is ticking here, the 11th Circuit and the Supreme Court. We're going to be here continuing to cover both, and we hope you join us as we do. Thank you for subscribing, and thank you for becoming a membo, joining us on our membos only streams. We had a great stream this morning, and we'd love to see you there on the next one. All right, my friends, now we're not done yet. We want, of course, to hear from you. But if you are just joining us, we had some major legal updates. So Supreme Court updates, waiting for the Supreme Court to issue a ruling. Let's do one final refresh while we're here. Anything? Nothing. All right, so we'll keep our eye on this one. Is Trump's sentencing happening tomorrow at 9:30 in the morning? Everybody's got their filings in. The Supreme Court is going to be issuing a decision, maybe tonight, maybe first thing in the morning, but it's going to be soon. All right, so we'll keep our eye on that. But if you're just catching up with us, we did read through a bunch of briefs. We read through Alvin Bragg's justification for why he thinks that the stay should not be granted and why the sentencing should move forward. I thought it was actually quite weak. And he's basing it on jurisdiction and preservation, which are two weak arguments. So I think the Supreme Court will come back out and do the right thing here. Then we talked about Florida and Jack Smith's report and whether it will be released or not. I, for some reason, have a feeling the J6 portion may come out. The classified document stuff may not be released, but the J6 stuff, we'll see. But now, my friends, let's hear from you and let's see what you say about all of this. Thank you for joining us, by the way. And if you haven't already made plans for the inauguration and you want to come to the White House in Scottsdale, it is going to Mar-a-Lago of the Southwest. Come and join us January 20th at watcherlodge.com. Grab your tickets. We're going to have an amazing watch party in person, and it's going to be a ton of fun. Grab your tickets. We're going to have food. We're going to have a huge video screen. We're going to have a photo booth. There's going to be a ton of people there. It's going to be classy, but a party. Not too classy and not too party. Just a beautiful combination of both. We hope to see you there. Watcherlodge.com. Grab your tickets. They're $100. We're not going to have a keg, I don't think. Probably not. No keg. Although, you know, inauguration keg stands, maybe. You want to do that? All right. We'll talk about it. All right. So, my friends, now let's see who's here on the day. And I'm really glad to see everybody. Thank you for joining us. Tomorrow, we're going to be here early. We're going to do an early stream. We'll go for probably quite a while in the morning. And then that will be our stream on the day. So thank you for hitting that notification bell if you haven't already. We got some great comments in, and thank you to Donut, Carrie B, K Bean, and our amazing mods who mod the fort down for us and clip things and make things nice and orderly here. Yeah, here's one. Happy Thursday. I mean, it's Thursday, right? I'm pretty sure. Yeah, I'm pretty sure it's Thursday. I sure hope so, because that's what I said at the start of the show. Thank you for that. Hey, Sheila Lawson, barely done. What's up, Sheila Lawson? Thank you for becoming a supporter. Wesley Holloway joined at shout-out level. Thank you, Wesley Holloway, for joining and supporting us there. Sheila, thank you for becoming a supporter. Grab that members-only stream this morning, and we do Saturday streams for our membos. We'll see you there. Ravicus says Smart City LA 2028. Smart City Strategy, Smart LA 2028. So they burned the whole place down, and then now they can rebuild it in a smarter fashion. Do you think the new smart city will be smart enough to have water in their fire hydrants? That'd be pretty smart. Maybe they should start there. Wendy W. What's up, Wendy? Thanks for joining us. We had a fun stream this morning. What the hell we talk about this morning? I don't know. I always have fun. So, I don't know. I say that a lot because that's fun. I don't know. And why? Trump's brief is a bit weak. Oh, brief. I was hoping it would have been written better and was grounded in his immunity and the defective trial, not this novel president-elect immunity. Yeah, the president-elect immunity thing is new, and it is novel, and we'll see if the Supreme Court bites on that. Which brief were we talking about? Which brief were you referencing here? I'm trying to think about which one. Because we read the Ed Meese brief. So we read Bragg's brief and Trump's amicus. Yeah, I understand what you're saying there, NY. Thank you for that. The president-elect immunity stuff is new. I think it's going to be a stretch for them to do that. But I think that the sentencing could easily be stayed on the other issues that they've already decided. The Trump case, essentially. The J6 case. Good. NY says, if it's not dispatched by the Supreme Court, I suggest Newsom be charged with some nominal made-up situation in a red state, specifically dealing with the time he spends out of state. He's visited red states, so make something up and charge him and then put it in limbo. Yeah, I think they call that the goose and the gander. Hey, Economath says, so what has Trump's New York case taught us? A, don't call it a legal expense. Call it a cost arising from lawyers' efforts. I like that. That's very good. Economath. It's not a legal expense. It's an expense that arises from a lawyer's activities. Yeah, I like it. It's very clever. What? It was an expense related to Cohen. What's the problem? Niels says, Bragg tells Ketanji she doesn't have jurisdiction. It was to Sotomayor, but yeah, to Sotomayor. The Supreme Court doesn't really like to hear that. We don't have jurisdiction? Okay, that's fun. I guess you're in charge. Okay, Alvin. Thanks for letting us know. You don't have any power here. Okay, Sheila Poo says, Bragg is an idiot and his filing proves it. Yeah, and Bragg didn't even write it. He passed it off to some other moron. Thank you for that. Stephen Wu, actually. Sheila Poo. That was an interesting filing. Susie Grosbeck is our latest supporter. Welcome aboard, Susie Grosbeck. Thank you for supporting our work. Ex Ante says, based on forecasts rather than actual results, or it's in a way that's based on forecast. We had some good Latin today, didn't we? Ex Ante. Rob says, the U.S. should not have had to put up with the Russia hoax, which the U.S. created. People should be prosecuted for that. Obama knew what was going on with Hunter and Biden, and I'm sure he profited from it. Oh, that's what we talked about this morning. The Carter stuff. That was a fun stream this morning on our Membo stream. We'll release segments of that later, but it was fun. The Obama-Trump stuff happening at the Carter funeral. Hey, it's the Munkets. Tony Hay bringing in 10 new membos. Thank you, Tony Hay. Look who's here. Jay Liebgott coming in. Is here. We got Sunshine McLeod, Carl Peterson, Threads of Hera, 300-yard wink. We got Corn Pope. What's up, J.E.? Robert the Great. What's up, Robert the Great? Welcome. Great to see you. Hey, and Gen Chicken 2006 in the house. Gifted membos. And brought in to the house. Sheila Poo. Hey, thank you, Sheila. 11 months as a membo. Almost one full anniversary there. Love you, Rob. Love this community. We love you back, Sheila the Poo. The community does too. We love you. Thank you, Sheila, for being here for 11 months. Lenny Malley, please smash the like button. Please do it. Lenny is asking you to just pause and hit it. You'll make him happy. Thank you, Lenny, for the reminder. Boopsy says their goal is to interfere with the presidency, period. Exactly. It's just like Russia. Or they'll impeach him for this, okay? They'll just, we're going to impeach him because he's a convicted felon and now he interfered with 2016. They're trying to delegitimize his 2016 win. They are so pathetic. They can't let it go. Hey, it's the Munkets bringing in 10 more membos. Thank you, Tony Hay. We got Chris Carson is here. Lizzie for Freedom. Maddie B. What's up, Super Iron Bob? Hork is joining us. We got Rex Turbo. Stephanie Rowland. J Dubs is here. Irene Abbott and Uncle Mooch in the house, brought in courtesy of Tony Hay Munkets. Hey, it's the Munkets. Thank you, Tony Hay. 10 more friends coming in. Rob says, Schumer Klobuchar swore in 12 lifetime lower court judges. What does this say about acting judge? Is Merchan a real judge who got all these cases specific to Trump, paid a fake judge and more? In my humble opinion. Yeah, they did. And the Republicans got blown out on that. The Democrats said, we'll give you a bunch of appellate judges. Just give us all these district judges. They said, sure, because they're dumb. Then they appointed all the district court judges and then the appellate judges unretired, and they're not going anywhere. Great job. Rocky Water says, Rob, your red marker underlining straightness and accuracy have improved greatly over the years. Kudos. Rocky, that's an interesting comment, man, because we're going through a red line. We're going through a red line, moment right now. I'm trying to figure out what I'm doing with the red line because as you've seen since our move up here to Prescott, I'm now operating the whole show off of a laptop. It's a bunch of screens and I got it all figured out now. But what we're doing now is scrolling on the mouse pad. And literally, I just bought a magic mouse to go along with this yesterday. And so far, I hate it. It's not working and it's pretty terrible to use. So I'm working on even greater improvements to straightness and accuracy as we speak by utilizing an external device. We're working on it. So I'll bet it's a technological improvement, not a talent improvement. Well, that just takes all the sail out of my wings. Here I was, thought I was getting better at it, but I guess not. All right. Anyways, thank you for that. Thank you, Rocky. I appreciate the dono. Our straightness and accuracy will continue to improve. You're going to get so tired of straight red lines. You're going to get tired of the straightness and accuracy. Rob, your lines are too straight and accurate. That's just too bad. That's how we do things. Barbara O'Sullivan. Thank you, Barbara, for becoming a membo and supporting us. Here, ipse dixit is an assertion without proof. Man, everybody knew this one except me. Assertion without proof. Thank you for that. It took me a minute to look that up. Knox, thank you, Knox, for the education. This one came in from Knox. Says, by the way, happy Thursday, all. Just had to jump at the chance to show off my legal Latinese. That's good, Knox. It's good. I'm not that good with my legal Latin stuff. Ray Ipsilock, remember those from Torts? Those were great. Knox, thank you for that. It's fun. It's fun. ELZ says the Dems are so used to beating on Trump, they just can't help themselves. It's like a nervous tick. They just wake up. Trump, Trump, Trump. They have to make Trump go through one last gauntlet before they take office. They can't live with themselves. Hey, what's going on, Rick D? What do you think the chances are that the DOJ drops the cases against the remaining defendants in Florida so they can try to release the whole thing? That's a great question, Rick. And at this moment, I don't know. It's going to look very obvious if they try to do that. I think it's probably too late to try to sneak that through. In other words, they would file a supplement with the 11th Circuit. Well, we just filed a motion to dismiss Walt and Carlos, and so now this is a moot point. There is no ongoing prosecution against them, and so now we're releasing both things. Yeah. Hey, Boopsy, can we watch your watch party on Locals, Rumble, or Circle? So the main feed, we're going to live stream a portion of the inauguration event. So Trump's inauguration and his speech, we'll live stream it. But then after that, we'll get off live. And then we'll do the after party, or the inauguration watch party will be on Circle. That's where the digital stuff will be. Cyrus Jalali says, what will the remedy be to Trump if Jack and Garland defies canon and releases the report anyways? What will be their punishment? A slap on the wrist? Yeah, no, I think not much, honestly. They can't unring the bell. Once the bell is rung, it's ringing, and the report will be released, and that will be the end of it. Jack Smith is not a U.S. attorney. He's not at the DOJ anymore. He doesn't care. So, she could sanction him, or she could imprison them, right? She could sanction them and say, you were in direct violation of a court order, and I ordered you not to do it, and you did. You're going to be sanctioned with something. But in all likelihood, not. What are they going to do if they release the report? Which is how they wanted to do that. They just didn't want them to be the people to do it. I think it'll come out. How does it come out? They didn't want to release it themselves. They wanted to delegate it to Congress. And we're just going to let Congress look at it and promise not to release it. And then they'll release it. So they were just looking for a third party to do it. Boopsy says, Judge Napolitano says after Trump is sentenced, the judge will give Trump the traditional opportunity to speak any final words, and he would be able to say whatever he wants for as long as he wants. Yeah, that's right. Well, actually, you speak before the sentence. So you would speak before, anything to say before the court imposes sentence. Your Honor, please, I'm sorry, okay, thank you. Here's my sentence. So, yeah, Trump could say whatever he wanted, and he couldn't sentence him to jail or prison or anything. But I don't want Trump to be sentenced. I think that that is illegal. This is why I'm so upset about it. Charles Beck, what's up, Charles? says, so in other words, that's not worth it. I don't, Trump can run his mouth from the White House for the next 4 years. I'm fine with that. I don't want the sentence because it's illegal. Charles Beck, the Supreme Court should order Merchan to dismiss all charges immediately. All charges immediately. We got a new reply from Trump on the docket. Breaking news. Here we go. This is in the Supreme Court case. Oh, so that might have been in. Let me see. I must be missing something. So let me see. Uncle Bozy says Fannie owes Judicial Watch $21,000 in legal fees. Pay up, Big Fannie. Yeah, that's good. And so there's a new reply from Trump on the docket. Maybe that is on this case. In the amicus. I'm not sure where that is. Okay, so I'll have to look that one up. New reply from Trump on the docket. That came in from Donut. Have to look whatever that one is. Oh, here's one. He named the Florida defendants in this letter just now and made it public. Office of the AG, dear Chuck Grassley and others. Interesting. Okay, cool. So maybe we'll see what that looks like in the morning. Thank you guys for flagging that for us. Rick D and Donut. Breaking news from us. Hey, Goofy for Jesus says, if SCOTUS hears the New York case, is that checkmate? Yeah, I mean, if the Supreme Court comes back down and says that the sentencing is stayed, even administratively, I think it is done. It'll be done. Roy Boy says, isn't the court closed today due to the funeral? I think today was an official day of mourning, right? So I think a lot of stuff was closed, but officially, but the Supreme Court will be handling this. Won't some, if not all, the justices be at the funeral? I don't know that I saw any of them there. We saw that this morning. I don't think I recognized any of them there, but they'll still be working on this case. Even if it's officially closed, they'll handle it. NY says, Rob, if Bragg puts in a filing, say a response to a filing Trump makes to the Supremes, if they accept it, that Trump's lawyer did not preserve his immunity defense and he objectively did preserve the matter for appeal, could that have consequences if it's done in the First Circuit federal system? Could Bragg be dinged for that? So if I'm reading it right, I think it's like you're asking if Bragg was violating a duty of candor to the court or was being dishonest. If Bragg says Trump didn't make the preservation, he goes to a different circuit, and that circuit finds he didn't preserve it. The Supreme Court can really review everything. So they're not bound by a prior ruling from a lower court. So if the First Circuit, the 11th Circuit, the DC Circuit, any of these circuits, they can find whatever they want. The Supreme Court can reverse it. Goofy for Jesus says, great coverage, Rob. Even hubby has been listening. Love the stream. Love the chat. Big hugs. Going to be a glorious next 4 years. Goofy for Jesus. Shout out to you. Shout out to your hubby. Thanks for watching and listening in. It is, I think, going to be a glorious next 4 years. We're going on offense, man. Offense is much more fun than defense is. And we've been on defense hard for 4 years, but not anymore. C. Edwards says, Democrats are just looking for the label convicted felon so they can use the J6 pseudo findings to use the 14th Amendment. They don't care about fines and jail times. They just want the label. They are very much label people. Their whole lives are based around labels. They change their labels, and that changes everything about them. Their whole lives. Crazy. So they really want it to matter and to stick. And I don't know that they'll be able to use it under the 14th Amendment. I mean, they could use it for impeachment, but I think that the political winds are so against them. They've done such a terrible job, and their governance continues to prove how horrible it is with new fires and things like that. So I don't know that there's the political will to do it, but you certainly don't like that it is opening up that even possibility. Thank you, C. Edward, for the nice dono. First super on a live stream. Thank you, C. Edward, for that. B.H. Williams says, I love the Magic Mouse. Try a trackpad to see if that's better. Well, I'm using the trackpad right now. The problem with the trackpad is it requires me to do this. And this is kind of an awkward position to be in for like 90 minutes. So like this is kind of a better position to be in if I can have my hand on the mouse rather than on the trackpad. See how that works? So I'm trying to figure it out. Major difficulties over here. Matt Boyd. Hey, thanks for becoming a shout out member, Matt Boyd. That's one tier up. You're supporting us even harder than you were before, and we're grateful for it. Thank you, Matt Boyd. Economath says, if Jack Smith was unlawfully appointed, doesn't that mean his report could be actionable libel for which he has no official immunity? Let's bankrupt him. Yeah, I mean, there's the other argument that there is no qualified immunity for him. And after the judge disqualified him, if he was still taking money, then he would, it's illegal appropriations. He's stealing money from the government. What's up, Economath? Thank you for that, Dono. Says it was on, there's a second page somewhere on the second page. I'll have to try to find it. It's hard to pull stuff up on the fly, but thank you for that, Donut. Knox says, not a good time to speak to the court. I advise my clients to say 0 before they are sentenced. Yeah, I think that's probably a good call. Probably a good call. Don't say anything. This just hit as well from Rick D. Temporary suspension of the annual hydrant testing for the fiscal year from Rick Donner from the department. Temporary suspension of testing for fire hydrants. Dumb. And Kareem. Hey, thanks, Rob. I really wish I could come to the inauguration watch party. I will keep an eye on future events on the Watcher Lodge for sure. Thanks, Kareem, man. We're going to miss you. And that's where the events are going to be. We're having a lot of fun with the events. AmFest was amazing. The inauguration party is going to be fun. And so we're going to try to connect. We're not trying. We're connecting offline as well as online because we're building a community and we have to also have some interfacing in the real life. So we're doing it. And Kareem, there'll be more. And we'll try to spread them around a little bit. We definitely want to do an East Coast event at one point in time, and maybe we can connect with our friends over there in Florida to do that. Sharpie Guy says, I hope Obama was laughing as Trump was telling him about what prison would be like for Barack and Barry. Yeah, we were having a lot of fun exploring that this morning. No, you're going to jail, Obama. You are. No, I'm serious. You're going to jail. I told you not to do the thing. You did do the thing. Obama's sitting there laughing uncomfortably. Rick D says, from Trump, Leo Terrell will be senior counsel to the Assistant Attorney General for Civil Rights in the United States Department of Justice. And so those came in, my friends. Thank you so much for sending those in. And I was trying to find that page 2 that we were looking at. And I'm still not finding it. I don't know what the heck I'm doing over here. All right, so we now, my friends, are going to wrap it up and leave it there. So plan is tomorrow. We still don't have anything. I just did another refresh on SCOTUS to see if there was a new brief, and I'm not seeing it. So we'll pause there for the night, and we're going to come back tomorrow in the morning to get into it again. As we wrap it up, I want to say thanks to our amazing mods, K-Bean, Donut, Carrie B, Playin' Hooky, Dog Digger, and Janek modding the fort down for us, and Elliot, our dock master, who docked the heck out of our live stream this morning. Thank you, Elliot, for those. And my friends, so the plan is tomorrow. I don't know exactly what time we'll be live, probably pretty early. 9:30, 7:30, probably 7 a.m. Arizona, 9 a.m. Eastern time. We might have a drop from the Supreme Court, or it might drop while we're live. It's going to be an interesting night, my friends, and an interesting morning. Trump might be sentenced or not. So we're coming back tomorrow morning. We're going to get into it again. Until then, let's say hello to our friends on X. Let me make sure I'm not missing anything. JB says, I hate to be so negative, but Trump has crossed the Rubicon, and we all know what happened to Rome. Yeah, we do. We do. Fortunately, Rome can act as a historical guide. And I think that if we did not have President Trump, we would have certainly been on the path to defeated America. Wait a minute. Do we have breaking news? No, not yet. Okay, so let's see what's happening on X right now, and we'll wrap it up. We're going over to locals for our members-only after party. James Pepper says the Supreme Court is closed today for the National Day of Mourning. B. Torn says there will never be another American citizen like President Trump, the 45th president of America. Look at that photo. Colonial Trump. Amazing. Thank you, B. Torn. James Pepper, what's up? Sargasmo, ipse dixit, says, my source is that I made it up. There you go. Hey, Tricia says, I was just searching for this, crossing my fingers. Miss Skeeter says, New York changed the law to even bring this prosecution in the first place. That's definitely for E. Jean Carroll, for sure. Prosecutors couldn't even give the defense what they were prosecuting for, and the judge gave the jury a buffet of charges, which is exactly right. It was like, pick a card, any card. Pick a crime, any crime. Pick an object offense, any offense. Doesn't matter to us. As long as you're happy with it, we're happy with it in New York. So great to see you. Hey, what's up? JB Based is here. Says, I just watched your video. Bragg repeatedly mentioned that Trump can appeal. Doesn't that admit that the sitting president would need to be involved in a criminal proceeding against him during his term? Should that alone get this case dismissed? Yeah, like exactly, right? Trump will continue to fight the criminal case throughout the appellate process. And it's an ongoing thing. And Trump's people brought that up too. They said, well, what if it comes back down on appeal? What if the Court of Appeal says, yeah, you used illegal evidence of presidential immunity, and so do the trial again? Doesn't dismiss it, but just says, I remand for a new trial. Then Trump comes out with a new trial 4 years later. It's nuts. After watching your video, I found it interesting how Bragg makes the assumption the 2016 election was due to fraud. Doesn't that insinuate the 3 justices Trump appointed are illegitimate? Yeah. They're saying his whole first term was illegitimate. A-Man and Dad says, if the jury heard any immune evidence, surely that catastrophically taints the case. That's Trump's argument. Exactly right. Can't do it. You can't commingle all that evidence into one prosecution. And so we got a reply from the president that just dropped, a 12-pager. Okay, so thank you for, why is that not showing up on my end? All right, thank you for that. Donut clipped and linked us to the actual article, which might be a good jumping off point in the morning. So thank you, Donut, for clipping that for us. There was a new reply. Let me just show you what it looks like. So a new reply came back out in support of the stay. So in other words, Trump filed the motion for a stay. Bragg filed a response. Trump filed a reply. We'll see what this looks like first thing in the morning, and as we await the Supreme Court's decision. So, my friends, thank you so much for supporting us, sending in all those amazing donos. Welcome to our new membos. Tomorrow, we're coming back early, and it's going to be a great stream. We're looking forward to having you join us when we come back. One more reminder, get your watch party inauguration tickets, watcherlodge.com. Invite your friends, invite your family. Come join us, because it's going to be lit. We also want to thank our mods and our meme smiths. We got Carrie B. Donut, Playing Hooky, Janek, Dog Digger, and Elliot, our meme smith. JB says, I agree with you that Trump was the best outcome. I'm just worried for the future of America. I'm definitely on Trump's side. Yeah, I wasn't reading that way, JB. And I understand what you're saying. It's like Trump is so close to now taking power. They tried to throw him off the ballot. They tried to raid his house. They prosecuted him 4 times. They shot him in the head and tried to shoot him on a golf course. Many, many things. And he still won. And now he is 10, 11 days away from having total power. And they're just done? Like the game's over? They're not doing anything else? Come on. What are they planning? What else are they plotting? They're not just rolling over. These people are lunatics. So I'm not saying that America is suddenly saved. In fact, I think the game is just getting started. We just played the prelims. We got the White House. Great job. But we got a lot of work to do, because what Joe Biden and the Democrats have done over these last 4 years has been insane in terms of their devastation. And there's a lot of work cut out for us to repair the damage. But Trump is a once in a lifetime figure, maybe a once in a multiple lifetime figures. And there's something happening. We're on a different timeline in America now. And I think I'm optimistic about it. I hope you are too. Thank you, JB, for that great comment. And my friends, that is where we will leave it on the day. We'll pause here for the evening. We're coming back early tomorrow, and we might have a decision on the Supreme Court later tonight, first thing in the morning, but we'll be back in the morning to unpack it. And then the Supreme Court will be in session with TikTok And I'm sure there's going to be a bunch of other stuff happening. So we're coming back in the morning, my friends. I want to thank you for being here. Thanks for subscribing. Thanks for sharing the show with a friend or family member. And of course, thanks for coming back here tomorrow, because we're going to be here in the morning and we got a lot of business to attend to. And in order to do it appropriately, we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. Silver Umbrella, great to have you as a new supporter, my friends. We'll see you right back here tomorrow. Make it a great night. Bye-bye.